case briefs, and so much more. LSData's got what you're looking for.
In 1972, a case heard before the Supreme Court of the United States thrust the Sierra Club, a grassroots environmental organization, into a legal battle with a titan of the entertainment industry, Walt Disney Enterprises, over a proposed ski resort. The crux of the dispute centered on a quintessential question. Can a party claiming a violation of federal laws sue without personal injury? The controversy began when Walt Disney Enterprises drafted plans to construct a $35 million ski resort in the pristine wilderness of California's Mineral King Valley. Access to the resort, which would require approval for a new highway and power line from the Department of the Interior, immediately caught the ire of the Sierra Club. Asserting its commitment to the environment, the club filed a lawsuit aimed at preventing federal officials from greenlighting the project. But the Court of First Instance, U.S. District Court, handed down an initial blow to the environmental protector when it issued a preliminary injunction in favor of the Sierra Club. The decision, however, was revered upon an appeal by the corporate giant at the Court of Appeals for the Ninth Circuit, essentially helping Disney dodge the legal bullet by seemingly inoculating itself from the Sierra Club's lawsuit. The appellate court reasoned that the Sierra Club did not personally suffer harm, hence didn't have the locus standi to sue. Persistent as ever, the Sierra Club managed to push the case to the steps of the Supreme Court, poised to set a legal precedent on the idea of harm and standing in similar lawsuits going forward. But the court of last resort, guided by the underlying principle derived from data processing case, held that parties seeking review must not only demonstrate an economic injury, but also an organizational interest in the matter. It decreed that non-economic damages such as aesthetics and recreational values were insufficient to establish standing. Ultimately, the Supreme Court held that the Sierra Club lacked the standing required to sue Walt Disney Enterprises for the lack of personal injury, turning a blind eye to other issues the club raised in its petition. The court concluded that the Sierra Club, despite having ecological interests, fell short of articulating a direct stake in the outcome, and its stand to simply protect environmental values constituted act merely in guardianship of personal value preferences.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.